Hello and welcome back. This is our final installment of these video lectures regarding the substantive areas that we've been studying this past semester. Today's installment will involve a discussion of employee torts, classification of workers, negligent hiring and retention, the hiring process, employee discipline, termination, and severance. I'd like to remind you to look at your handout material or the course supplemental material that has been provided for this and last week's assignments. Make sure that you review those because much of our lecture will be based on those materials. Sorry for the delay with that. Had some technical difficulties, but we're going to start first of all with the topic of employee torts. Now, we've already encountered some of these torts earlier in the course, invasion of privacy, defamation. So let's talk about employee torts. I've put these into two columns. The column on the left involves torts that are based on intent. In other words, the conduct is intentional or carried out in such a way that it's been reckless, disregarding the rights of the injured party. The other side of the column is negligence, where we're not focusing at all on the intentional conduct, but the conduct which is caused by neglect or by accident, when there has been a duty to either act or not act in order to keep the third party, the plaintiff, if you will, safe and free from harm. So we're going to cover these torts today in our discussion, with the exception, of course, regarding invasion of privacy and defamation, assault, battery, false imprisonment, tortious interference, intentional infliction of mental distress, and retaliatory discharge, remember, is also a tort. And then the negligence torts will be negligent hiring, supervision, and retention. And all of these torts do relate to workplace settings and have certainly been part of our litigation history throughout this jurisdiction and jurisdictions elsewhere involving employment law claims and applicable defenses. Let's first start with the tort of assault. Assault is the tort of intentionally causing a reasonable apprehension of imminent harm or offensive contact. The threat to inflict injury places a person in fear of imminent bodily harm. That's harm that's occurring at the moment, not next week, not next year, but immediately taking place. Assault is often followed by the battery, but is a separate, independent tort. Now, battery is the offensive touching of another without consent or excuse, resulting in harm. Harm may be manifested both by physical and mental injuries, or physical injuries and mental distress. Either can be present and part of the claim for damages. Now, you'll probably also recognize that these torts, assault and battery, can be crimes. Often they involve the same set of circumstances, the same conduct, but our focus is on the civil aspect, not the criminal application. The tort of false imprisonment. False imprisonment occurs when there has been an intentional and unconsented restraint or confinement by one person of the physical liberty of another. False imprisonment can be accomplished by words alone or by physical actions or restraint. Conscious awareness of the restraint and resulting harm are required. Can you think of a situation involving a workplace setting where false imprisonment may be raised as a claim? Courts have addressed this situation with lawsuits in which an individual has claimed that they've been blocked by their path or in their path from exiting an office, they're restrained in their office, they're not allowed to leave a car, their movement has been restrained in some way. Those types of matters can lead to a false imprisonment claim, where one's liberty of action, one's confinement has been obviously impaired by the exercise of another's intentional actions. False imprisonment is a claim that often finds itself in employment litigation under common law. The tort of tortious interference, and I've put in parentheticals on this slide, with prospective economic advantage. Now, we've talked about a claim of defamation with respect to negative referencing. If we go to the example where a former employer intentionally informs the prospective employer that there's been some negativity associated with the former employee's employment, false representation perhaps of the quality of their work, or something stating to the extent that they've been fired for a cause when indeed they may not have been, where the employer has inserted themselves into the prospective relationship that that new employee, I should say the former employee, is trying to have with the new employer, such that the new employer doesn't hire the employee or fires the employee because of that former employer's communication, can lend itself to the tort of tortious interference. And the tort would require the following elements to have been present. Excuse me. One, a reasonable expectation of entering into a valid business relationship. Now, you can substitute that for an employment relationship. Two, the defendant's knowledge of that expectation. So if, for example, the new prospective employer is calling about a job reference and the former employer is giving a negative false reference, well, that type of communication could lead the prospective employer into not hiring or extending an offer to the employee. That's where there's that potential expectation that has been interfered with. The third bullet point here would be a purposeful interference by the defendant that prevents plaintiff's expectation from ripening into a business relationship. Now, you might want to insert a employment relationship there instead. And that's the example that I just had commented upon. And then, of course, damages to the plaintiff resulting from the interference. The damages would be not getting the job or being terminated from that position. Tortious interference with contract under Illinois law. Keep in mind that an employment relationship, as we've talked about many times already, is contractual. So for a plaintiff to establish a tortious interference claim with contract under Illinois law, they must, one, show the existence of a valid and enforceable contract between the plaintiff and another. That other could be the employer or some other organization that they're performing services at. Two, the defendant's awareness of that contractual relationship. Three, the defendant's intentional and unjustified inducement of a breach of that contract. In other words, where the former employer or someone else has intentionally tried to interfere with that contractual relationship between the plaintiff and the other party, such that the other party decides to end that relationship based on the communication or based on the action of the defendant. Next bullet point would be a subsequent breach by the other caused by the defendant's wrongful conduct. In other words, where the contract has indeed been terminated based on the unlawful interference. And then, of course, damages must be established for there to be a tort. let's look at the tort of intentional infliction of emotional distress. Now, this is a tort that has been filed in many employment actions in various jurisdictions, including that here in Illinois. I have an entire article that was submitted to you for your review and your analysis involving this tort. It's what, an 18-20 page article. It was part of a presentation I made several years ago to a bar association group, but I've talked about these topics within that article to many college classes and law school classes as well. So let's focus on that. To prove the intentional infliction of emotional distress, the plaintiff must prove, one, that the defendant's conduct was extreme and outrageous and intended to inflict emotional distress. And we'll talk about extreme and outrageous conduct in just a moment. Two, the defendant knew that there was at least a high probability that such conduct would indeed inflict severe emotional distress. And three, indeed, the defendant's conduct did cause severe emotional distress upon the plaintiff or the employee. Now let's look at some of these various points. Extreme and outrageous conduct. A liability, that's legal fault, will not apply to mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities. That's from a case that's litigated and reported in 1976. Personality conflicts and questions of job performance are unavoidable aspects of employment, and that frequently they produce concern and distress. However, those types of matters do not relate to intentional infliction. What does is that the behavior or the conduct must be objectively reprehensible. In that handout, which if you haven't read, please do, it's entitled The Tort of Intentional Infliction of Emotional Distress in the Context of Employment. Make sure you read that. There's a lot of information within that article and some facts that have been brought out in these litigated cases that are very disturbing, very distasteful. Objective, reprehensible behavior was noted in a case called Pavilon versus Cafferly that was litigated in 1990. I'm not going to repeat all of those facts in this topic discussion here, but make sure you read it. Threats of physical abuse may be factors that go into the reprehensible conduct. Threats of coercion and retaliation. There's been a case that has held in Illinois that where the employer engaged in an extensive course of disciplining, yes, disciplining, and harassing conduct to coerce the plaintiff to falsify certain work reports, that the claim for intentional infliction of emotional distress was recognized. And that was a case back in 1981, still good law today, called Milton versus Illinois Bell Telephone Company. And again, that's referenced in this handout. Abusive, disparate treatment is also a factor. The degree of power, authoritative position over the plaintiff are factors to consider. The more control which a defendant has over the plaintiff, the more likely that the defendant's conduct could be considered outrageous. So make sure you read this and go through some of these examples. And again, it's certainly situations that have been reported here that are just awful, but that's what the conduct is. It's awful, outrageous, reprehensible conduct, which the courts have called or recognized as a separate tort, the tort of intentional infliction of emotional distress. Now, I like to describe this tort as a recognized common law claim that is actionable. Actionable means there can be a recovery, a financial recovery to the plaintiff if successful. You've often heard the topic of bullyism. Well, bullyism may be really a form of intentional infliction of emotional distress. There's no law or recognized common law claim for so-called bullyism. However, where that conduct rises to this level, the independent tort, common law tort of intentional infliction of emotional distress may be applicable. So consider that in your studies and in your analysis. With regard to damages, if the tort of intentional infliction of emotional distress is actionable and leads to a recovery, these are the types of damages that may be available. Punitive damages, we know what that is. It's designed to punish and to deter that type of conduct, by example, from happening again elsewhere. Compensatory damages, we know what that is. Compensatory damages are to compensate, which are different from punitive damages, which are designed to punish. Now, interestingly, the courts over the years have ultimately determined that there need not be any type of expert evidence that's required. In other words, the need for psychologists, psychiatrists, or even other medical healthcare professionals are not necessary to prove the damages that relate to intentional infliction of mental distress. Lay testimony, non-expert testimony, has been recognized and is available to prove damages. Years ago, cases also required a showing of physical injury. In other words, for there to be a claim of a mental battery, and really that's what an intentional infliction of mental distress claim is all about. It's a mental battery, not a physical battery. But if there is this mental battery, there needed to have been some physical manifestation that can be at least recognized or measured. Well, over the years, courts have allowed these types of claims to go forth and be considered by a jury, even when there's not any physical manifestation that's been present. Now, what might be a physical manifestation of the intentional infliction aspect? It could be the physical response of, becoming ill, having some type of physiological aspect that ultimately reflects, the intensity of the distress. And of course, economic damages can also be available as a remedy. Let's talk about the tort of negligent hiring. I've included negligent supervision within that context and negligent retention of employees. We've actually used these terms before in our studies, and I mentioned at the time that we'll revisit the concept of respondeat superior later on. Well, now is that later on time. Respondeat superior, we know what that means from our previous readings and study. It means let the master, which is the employer, respond to the acts of the employee. Now, under common law, the employer is liable only for those torts or actions that lead to injuries committed within the scope of employment and in furtherance of the employer's interest. Where the employee committed harm that goes beyond the scope of their employment functions or goes beyond what they were expected to do in a workplace setting and causes injury to some third party or someone else, that respondeat superior type of liability will not be available. So as a fallback, if you will, there could be a negligence theory that's been asserted, and that negligence theory falls within the framework of the torts of negligent hiring, negligent supervision, and negligent retention of employees. Negligent hiring supervision and retention theories have been used to impose liability in cases where an employee commits an intentional tort, but outside of the scope of their employment against a customer, the general public, or even co-employees and others within a workplace setting. The theory is that the employer knew or should have known, there you go with the negligence aspect, that the employee had a propensity to commit harm, but the employer was negligent in preventing such harm from occurring. To establish negligent hiring, for example, a plaintiff, that's the person who's been injured by the actions of the employee, must prove that the employer knew or should have known that the person hired had a particular unfitness for the job that would create a foreseeable danger to others. Now, foreseeability is the key. Foreseeability involves anticipating the potentiality of harm when information was available or could have been available for consideration before that harm even occurred. In other words, where there's notice that is available to point out that there might be in the future the likelihood of some type of harm occurring that related to this individual's conduct or propensity for such conduct. Courts have looked at a particular unfitness of the person that caused the harm as being the so-called proximate cause of the plaintiff's injury. The proximate cause, that's a legal term in negligence, meaning that it is the reason for the harm, the underlying reason. It might not be the actual reason, but it's the underlying reason for which legal liability really originates and can attach to a defendant employer. Let's talk about negligent hiring in more detail. Negligent hiring decisions by courts involve the analysis of the particular job and potential risk. I've cited a paragraph within a case in 1979 that was decided, and I thought that this paragraph is really a good description. It has a lot of legalese, of course, but it's a good description of the hiring decisions that ought to be considered and where liability may be imposed. The quote paragraph, or the paragraph in quotes, is as follows. Moreover, it has been held that in the selection of an agent, now the agent, of course, is the employee, an employer will be held to the exercise of care reasonably commensurate with the perils and hazards likely to be encountered in the performance of the agent's, now think of employees, duties, that is, such care as a reasonably prudent person would exercise in view of the consequences that reasonably would be expected to result if an incompetent, careless, or reckless agent was employed for that particular duty. End quote. What is that really saying? It's foreseeability language that must be considered. Is the employer on notice, or should have been on notice based on their efforts early on, perhaps in the interview or the job reference stage or background check stage, where they could learn that there might be a propensity for such conduct or behavior that is foreseeable into their workplace environment. We'll talk about that in more detail in just a moment. In that Easley case, the appellate court upheld a trial court decision finding a security company liable for negligence in hiring an armed security guard who used his employer-issued key to gain entrance to an apartment and attempted to rape the occupant. The company did not check the security guard's prior addresses, personal references, or criminal history prior to hiring that employee. And again, in our course materials, there's a lot of information about negligent hiring that if you haven't looked at already, I'm going to remind you again, please do so. Lots of information. Let's talk about negligent hiring again in a little bit more detail. Most situations involve an employee injuring someone, which could have been prevented if the employer reviewed the background of the employee prior to hiring. Arrest and conviction records are public records. Illinois law bars employers, however, and prospective employers from getting access to arrest records that did not lead to convictions. Now, you'll note from previous studies in our discussion that the Illinois Human Rights Act, for example, prohibits arrest record discrimination. If someone has been arrested and they're denied an employment opportunity because of that arrest, that is discriminatory under Illinois law. It's a violation of the Illinois Human Rights Act. However, if someone has been arrested and there's been a conviction from that arrest, that is a different application. Background checks are best conducted after an offer of employment has been extended, conditional upon such employer investigation, with, of course, the consent of the employee. So, offers can be made conditionally depending upon what the background check information reveals. And this can be done very professionally, competently, and may also eliminate the potential exposure in some circumstances to negligent hiring claims. And again, I'm going to ask you to look at your textbook for more information about that, as well as in the handout materials. Let's talk about the textbook case of Bryant versus Lavigne. Now, I've mentioned earlier in our discussions here on these video presentations that in our textbook, which is national in scope, Professor Twomey has selected cases from all over the country, but I said to you earlier on when this course first started, don't be surprised about the number of cases that originate from Illinois court jurisdictions. Here's another example of a leading case from Illinois that ends up being reported in this national case law book that Professor Twomey has put together. Let's look at the Bryant versus Lavigne case. In that case, and I want you to read that case very carefully, very closely, because there are many facts which lead to the jury's conclusions accordingly. In the case of Lavigne, Lavigne was a manager of the National Supermarket Store. After drinking alcoholic beverages, and I'm reading from the introductory paragraph, one evening he stopped by the store. He stopped by the store to check the operation and observed a 10-year-old boy's unacceptable behavior outside the store. Lavigne chased the boy to a car, where he then pulled a 4-year-old child named Ferris Bryant from the car and threw him in the air. A multi-count lawsuit was brought against National and Lavigne, so he's also named individually, which we've talked about individual liability earlier in this course. A verdict was rendered against National, that's the employer, for $20,000 as or on a respondeat superior theory for battery of Ferris Bryant, and a verdict was also rendered against National for $15,000 in negligent retention of Lavigne, and for $115,000 punitive damages for willful and wanton retention. The Bryant case involved respondeat superior liability as well as negligent retention liability. the jury concluded that the actions of Lavigny in attacking Ferris were committed within the constraints of the authorized time and location of his employment, thus bolstering a finding that the battery occurred within the scope and course of his employment. The appellate court sustained, that means upheld, the jury verdict in the trial court's decision, finding negligent retention and respondeat superior liability. So please read this case in detail. There's many facts, and the nuances from those facts ultimately established why the jury concluded there was negligent retention and why the court allowed claims of negligent respondeat superior liability to attach. Now, with regard to that case, if you see cases where there's also a dissenting opinion, read the dissenting opinions. If you haven't already, make sure you read the dissenting opinion in this Bryant-Lavigny case. Consider the thoughts here of Justice Welch. His concern is that imposing on employers, as a result of this case, the potential requirement of checking court cases or doing background checks for ongoing, currently employed individuals could create an unreasonable burden. And that's the basis of the dissenting opinion. So think about that dissenting opinion. Often, dissenting opinions later on are adopted by other courts' decisions or could sometimes become the majority opinion of the court in future years. The case of Bryant versus Lavigny is an excellent case to really help you understand not only respondeat superior in more detail, but how negligence theories operate as a matter of law in workplace settings. Let's talk briefly about damages for negligent hiring, supervision, and retention. Compensatory damages are available. Economic damages are available, such as back pay, front pay, and of course, from your reading of the Lavigny case, punitive damages are also available. Something I want to bring up as a legal defense, often against these common law claims, would be the exclusivity of workers' compensation laws. In Illinois, we have, of course, the Illinois Workers' Compensation Act. It has been ruled in some circumstances by courts as the employee's exclusive remedy for so-called accidental injuries arising during the course of employment. Courts have held on occasion that an injury which was intentionally inflicted on an employee by another employee is considered accidental for purposes of the Illinois Workers' Compensation Act if it was unexpected and unforeseeable from the injured employee's point of view. When the person who intentionally injures the employee is not the employer in person or a person who is realistically the alter ego of the corporation, but merely a foreman, supervisor, or manager, courts have said that both the legal and the moral reasons for permitting a common law lawsuit against the employer collapse, or in other words, are not present. Courts have ruled, however, that the exclusivity provisions of the Illinois Workers' Compensation Act do not apply if the injuries were intentionally inflicted by the employer or by its alter ego, or if the injurious actions were commanded or expressly authorized by the employer. There's a section in the handout material for the article involving intentional infliction of emotional distress, which describes this exclusivity provision in a little bit more detail. I think from a big picture perspective, if there are these common law torts that apply to workplace injuries, in other words, where people are hurt on the job based on the actions of employees within the workplace. There might be a situation where the exclusive remedy isn't through the courts by application of these common law torts, but through the Illinois Workers' Compensation Act and similar acts in other jurisdictions. It's complicated. It's also a relevant part of litigation in these settings. I don't expect you to have a good comprehensive understanding of how it all works, but I just wanted you to be aware of its existence, and it's a matter that I think is important for consideration, and especially for human resource professionals too. Let's move on and talk about proper classification of employees. That's in your course textbook. Proper classification of employees. I've got to get it in my textbook. Is obviously essential to avoid liability for a variety of claims and the imposition of taxes, fines, and related sanctions. If the individual is an independent contractor who has earned more than $600, the employer must supply an IRS Form 1099 to each contractor stating the amount of money paid the contractor during the year. If the employer hires an employee, the employer must have an employer ID number, pay state and federal unemployment taxes, provide workers' compensation, withhold payroll taxes, both state and federal, and submit payroll tax returns monthly or quarterly, and pay Social Security taxes equal to the amount withheld and paid by the employee. None of that is required if there's an independent contractor relationship. If there is an employment relationship, then all of those factors and requirements must be met, because it's a matter of taxes, it's a matter of fines, and other sanctions that could occur if not. Those benefits, for example, such as vacation, sick pay, 401k, pension, are not traditionally available to an independent contractor, but may be to an employee. Let's talk about misclassification of employees in some detail, and I want to draw your attention to your textbook, if I can find my textbook section. If you'll look at the case, which is actually on a footnote, and I've asked you to look at footnotes before in this course, look at the footnote on page 622, Nationwide Mutual Insurance Company versus Darden. The Supreme Court sets forth factors to be considered in determining whether temp or temporary workers are common law employees of the company for which they perform services. The factors which the Supreme Court sets out as relevant are recruitment, training, duration, right to assign additional work, and control over the relationship between workers and the employment agency. Now, that case, of course, deals with temporary employees, but those are factors which need to be considered in determining whether there's been a so-called misclassification of employees. We've also talked about misclassification of employees earlier in our course with respect to the Fair Labor Standards Act, that's the FLSA, and unpaid worker or unpaid overtime claims. So here we go again. We need to find out how employees are sometimes improperly classified as independent contractors when in fact they're really truly employees. Take a look at the chart that's figure 16.1. I see there's a typo here. It's 16.1. Questions for ascertaining independent contractor or employee status. This is a wonderful chart that Professor Twomey has put together, and make sure that you go through this carefully. There's a number of questions that really point to whether an individual in a workplace hired by an employer is an employee or whether they are truly an independent contractor. Keep in mind that even though someone who signs a contract saying that they are an independent contractor, they may not in actuality be an independent contractor regardless of that contract that's been signed. So either party, for instance, the employer and the independent contractor, may think at the time that there's an independent contractor arrangement by intent, but in terms of actuality of conduct and circumstances, that employment arrangement may be more of may be more of an employment arrangement than an independent contractor one. And certainly the distinction is very important and can lead to liability and tremendous economic aspects to either party, the employer and the respective contractor / employee. Let's just look at just a couple of these questions. Is the employer the individual's sole source of income? In other words, if the individual worked for other organizations, then it may suggest that their employment truly is independent from the employer, but where their source of income is truly and solely dependent upon that employer, then there might suggest an employment relationship rather than an independent contractor one. Another good question to ask would be, does the employer have other employees on the payroll that performs the same type of work? Again, not determinative in and of itself, but certainly could be informative and might be a factor to consider. There's a number of tests that are used to determine independent contractor or employee statuses and definitions. There's common law test. There's test imposed by the IRS. There's also a test imposed by the Department of Employment Security here in Illinois. And then, of course, there's common law applications as well. So that's a topic that we should have some familiarity with and a working knowledge, because it truly is an important aspect of employment law in our study and in our coursework here. Let's finally look at the hiring process, which will conclude with termination and severance. Again, I'm going to ask you to look at your handout materials. As we've learned, various employment laws apply to not only the employment relationship, but previous to that relationship occurring. And we talked about earlier in this course how anti-discrimination laws in particular focus not only on the employment relationship, but conduct of the employer prior to that relationship and conduct after that employment relationship has concluded. In your handout material, there are some considerations that I've outlined, such as establishing hiring objectives before seeking employees. Along with those hiring objectives, there might be good reason to have a detailed or perhaps a general job description. A detailed job description might set forth the essential functions of the job that, of course, may relate to matters involving, the Americans with Disabilities Act. Use of advertisements has to be very thoughtfully considered. In one of your discussion point questions this week, there was a topic involving an advertisement. Certain words ought to be avoided in advertisements for positions. Avoid inferences of any type of long-term tenure, because most employment, unless it's intended otherwise, is of an at-will nature. Long-term references could convey that at-will employment relationship truly, by implication or circumstance, it is not. So there's a section in that handout material about that aspect, so make sure that you read that as well. Pre-employment interviewing. I told you early in this course that we would be talking about pre-employment matters at the end of the course, and we are doing that for a reason, because having now looked back over the last 14, 15, 16 weeks and our course of studies of these employment topics, I think we can better form assessments and have better awareness and opinions about what's prohibited and what's not if we learn first along the way what these laws actually provide, so that when we look at the employment relationship actually beginning, we have a good understanding of how these laws apply and what effects they actually have. So the interview process can be scrutinized for potential discrimination claims. There is generally always an opportunity to solicit business-related necessary information without violating the law or exposing the business to potential liability. Please reference the pre-employment inquiry checklist of illegal and legal hiring inquiries found within the course materials that are provided. Now, please note that this checklist is not exhaustive and does not relate to every situation. And by the way, I did not make up these different questions and categories here. These questions and categories and examples are from EEOC and court cases that have been compiled for this application. So let's just go through a few questions to avoid in a pre-employment interview. Would you want to ask, for example, how old are you? No, that would be a prohibitive question. How long do you want to work? Well, that too might be a prohibitive question. What's your birthplace? How long have you lived in this country? Those would be prohibitive questions, but not just prohibitive questions because they're bad questions, but think in terms of what categories that these questions may fit within regarding the anti-discrimination protected classifications, which we now have a good comprehensive knowledge of. So with respect to, for example, religion or creed, the anti-discrimination aspects of Title VII with respect to religion. Should you ask, do you observe any religious holidays? What church are you a member of? What's your religion? No. Those would be examples of prohibited questions. Likewise, with regard to the Americans with Disabilities Act, would you want to ask, do you have a disability that would prevent you from performing this job? No. That would be a prohibitive question because it could lead to information that otherwise is private, confidential, and not relevant to disclosure. But here's an alternative. Would you be willing to take the company physical if required for the job? Now, that might lead to a level of discussion that certainly would not be prohibited. Do you have the ability to perform the job with or without accommodations? That's not a prohibitive question, but there may be some inquiries that are prohibitive that relate to requirements of the specific job or do not relate to requirements of the specific job that, if information is provided, could end up being a litigatable issue, or at least a part of a charge of discrimination for failure to hire that might be investigated by the EEOC. I've broken down these categories into different sections, all of which we've talked about throughout this course. Family status, marital status, sexual orientation, gender, all of these points have been discussed, and hopefully these will give you some examples of what types of categories of questions and specific questions should never be asked in interviewing for prospective employees. Next, let's talk about employee discipline. A considered, consistent discipline policy that's documented and communicated to employees permits the employer to take measures towards corrected harmful or counterproductive behavior, while at the same time reducing the likelihood of generating a charge of discrimination. Documentation of the problem or corrective measures taken are very powerful tools for the defense of claims of illegal discrimination, as well as supporting a misconduct defense to an unemployment compensation claim. Lots of information about terminations within the materials that you've been supplied, in addition to the course readings. Let me just focus on a few more categories here. With respect to termination, there's a termination checklist, which is in the handout material. Again, just for reference purposes, you can go through that all on your own. But terminations can be voluntary or involuntary. Now think about that. By this, it's meant whether the employee has chosen to quit his or her employment or has been fired. Employment is generally at will, which we've discussed. In fact, by way of overview, all of these laws, which we've spent so much time and effort reading, studying, talking about in our discussion point exchanges, and in your testing, all relate to exceptions to this at-will employment doctrine. So, if, however, the employee is subject to an employment agreement, a collective bargaining agreement, or is a public employee, there might be some special rules which apply. The provisions of the employment agreement or collective bargaining agreement must be followed in terminating such individual's employment, because if not, there could be a breach of contract claim. Also, if the company has a handbook or guidelines for termination or has informally followed certain policies in termination, whether written, published, or not, in the past, these policies must be consulted and past practices should be examined. The termination should never be for reasons which would give rise to a claim against the employer, such as discrimination, retaliation, etc. And again, there's lots of information in that handout material supplement that you've received. Severance agreements. Briefly, I wanted to talk about severance agreements unless required by contract, such as a separation pay plan or a severance plan, or an agreement otherwise. Severance is not mandated by law. Severance is considered as a gratuity. The historical purpose of severance is to allow a terminated employee transition money, if you will, to bridge the period between the job loss and the replacement employment opportunity. State unemployment compensation benefits also provide supplemental income for such transition period between employment. Employers will often treat the severance as contract consideration to bind the employee's promise in return for the release of claims, waiver of rights, and other conditions. Now, just as a reminder, you may think about the Older Worker Benefit Protection Act. That related to severance offers that are governed by federal law. But unless the Older Worker Benefit Protection Act applies, these other considerations should be certainly factored in the analysis and what the employer does or doesn't do. So that would conclude the information within this segment. Lots of information here that combines a couple of weeks of our studies, but I think it serves also as kind of a very broad general wrap-up of our course in particular. I hope that you have enjoyed the course. I hope that you've learned from our discussions and your reading, and of course you've learned from each other, which has been a big part of the overview of this particular online design course. If you have questions, comments, or other information that you may require, feel always free to contact me. It's been a pleasure. I wish you all the best and most success, of course, in your final exam, which I'm sure you'll all do very well on, but in your work lives and continued efforts as a student otherwise as well. Best of success to all of you. Thank you.